Olwaleero nkulabidde Katemba atali musasulire ku kkooti y'amagye Makindye gye bayita Tribunal oba akakiiko akawozesa bannamagye abazizza emisango. Olwaleero abadde Katemba mwereere ekibadde wali Aso tubirabe bulabi naye weerabire Katemba kuba oyinza okugamba nsudiriza naye njaga Katemba omwerabire bwerabizi. Kano Dr. Kiiza Besigye wadde aleeteddwa lunaku olwaleero ne munnamateeka we Martha Kaluwa.
Council. The last time we appeared here, we had adjourned on a note that their processes we are still pursuing, Mr. Chairman, regarding her practicing certificate to be able to have audience before this honorable tribunal. It's actually on that account that this honorable tribunal deemed it necessary to have the proceedings deferred to allow us that time to finalize the process. Where we stand today, the status quo has not changed, Mr. Chairman. There are matters which are still before the Law Council. We have gotten a communication from the Law Council which we would like to share with you, Mr. Chairman, and the response has been made by the senior counsel here. We are waiting their pronouncement on the same or further processes because we feel this is a matter of great concern to not only the accused persons but also this honorable tribunal, given its centrality on the constitutional processes in this country. Mr. Chairman, I don't need to delve so much into the provisions of Article 28. Actually, read together with Article 23, the right to fair hearing, and the cornerstone of that particular right, part of it is indeed effective representation of the accused persons. And the accused persons have got a prerogative which is constitutional in nature to choose lawyers they deem competent enough to deal with their matter. And under Article 28, this honorable tribunal is enjoined facilitate the accused persons with all what they require to be able to prepare their defense effectively. And one of the tools they require to effectively prepare their defense is to have a formidable and competent team duly constituted. So in a nutshell, Mr. Chairman, we are still in the process of having our legal team fully constituted because right now our legal counsel has not been cleared by the Law Council, and there are good issues that have been raised by the Law Council, one of which being, Mr. Chairman, the need to prove that there is value addition she's going to make in this matter, and that will prove that indeed her presence in this matter is critical, is important for effective dispensation of justice. We intend to do that because it has been one of the key issues raised by the Law Council. The other issue they raised that they have no precedent of this nature where there's been a cross-border practice in the criminal matters. That in the history of this country, in all the jurisprudence we have never had a single criminal case attracting a lawyer from a foreign jurisdiction. That is something which is equally fundamental. We want to establish whether indeed representation a jurist from a different jurisdiction is restricted to civil matters because that is a contention within this ruling of the Law Council. And finally, Mr. Chairman, the question of East Africa integration. Mr. Chairman, allow me, with your permission, Mr. Chairman, I just want to prove to court that the Honorable Martha Karua here holds an East African passport, which is a valid document in Uganda.
I think Council Kwaku, we are not going into those issues. We all read the news about the decision of the Law Council. You tell us the way forward to the press court and how we are the next thing.
Mr. Chairman, I wasn't advised that the court had read newspapers. So it's the reason I was laying the foundation. For this case, I thought court acts on evidence, and I wanted to submit this to court for record purposes. And with all due respect, I don't know which newspaper I can quote.
That being the case, we have talked before court started, and even we agreed that she has to be given a seat, but she will not participate in the proceedings. So if you are the one leading the team, proceed about the case.
Precisely the point I was making, I have not been instructed to lead the team. The instructions to lead the team remain with the Honorable Martha Karua. And that is the point I very much wanted to put on record to guide the proceedings.
Now, wabanga omuntu tanaba kuweebwa kiwandiiko lukusa certificate yamukkiriza kuwoleza mu Uganda, why she comes always? Okitegedde lwaki alemerako n'asigala nga jange kiwebbaluwa baagimumye? Is it a protest? Katemba batekawo vibe ku vibinga kulaba ng'ekintu kya Besigye kikwata kisituka waggulu. Kambuze kyekigwanidde tuli mu protest court oba tuli mu protest tribunal? Okitegedde kuba bw'abanga omuntu yagaaniddwa yamiddwa ekiwandiiko ekiwoleza muno, lwaki ate mumuwa siiti atuule nga mwamumye ekiwandiiko? Mumugambe n'okutuula tatuula kuba talina lukusa. Tutula wali bannamateeka. Okitegedde talina kiwandiiko kimukkiriza kuwoleza Uganda, naye nti ate alina East African passport. East African passport bw'oba ogirina kitegeeza oli free okubeera wonna weyagala mu East Africa, era kitegeeza oli free okukola byonna by'osobola okukola mu East Africa ebikolebwa wano Uganda. Bwemanga nina kyensobola okukola nga munnansi, nga waliwo munnakenya alina passport ya East Africa naye asobola okukikola wano kuba mwana wa East Africa. Nange nsobola okugenda n'okola byenkola e Kenya bwemanga nina East African passport kuba etukkiriza okuba nga tuli wamu. Kitegeeza tutambula free, tukola bye tuteekeddwa okukola mu East Africa within nga tubikola nga East Africa nga tewali akubwa ku mukono. Kati bw'obanga Martha Karua alina passport ya East Africa, ki ekimugaana okuwolereza Dr. Kiiza Besigye? Ki ekimugaana okubeera lead counsel? Oba ondaba waliwo katembano gwe bali mu kutuzannya batuteeke mu kubunkenke, fena mind zaffe tuziteeke ku kano Dr. Kiiza Besigye aveeyo ng'alina vibe, bali mu kutwala eri mu 2026 mwe temunnaba kulabayo. They are trying to shift the minds of people. They are trying to shift the dedication from Kyagulanyi Center mu Robert Bobi Wine batutwala wa Dr. Kiiza Besigye. Ate obuzibu bwenfunye nti n'abakulembeze ba Nuupu bakiguddemu kino. Kale siganye kulaga diplomacy, siganye kulaga buntu bulamu, siganye kulaga togetherness, naye bakibawaludde paka lwe bakibasuddemu. Kyazze kitya? Mpuga bwe yabadde nga atongoza ebintu esimanya DI yagambye ne basiba Besigye ne mutalabikako nga Nuupu bali eri batudde the leading opposition party waise na kubina zula nga lopa ayise olukungana abakulembeze mu parliament. Yamaze okulita waliwo bakedde nabo mu kooti, badde bujjo tebagendayo, olwo bonna bakedde mu kooti bonna. Kale siganye to show solidarity naye General Museveni wabadde abaagala bulijjo abateeke mu tulimu abasituliraawo abajja ku bye mbadde mulina okukola. abajja ku programu ze mubadde mulina muna focus mugiteyo ku Besigye bagenda okuta Besigye nga buli muntu akyacanta iye bamutadde owafeeyo yasobola dokita asobola. Just keep your eyes on the screen and see. Ogenda kulaba gye birina okuggwera bino ebintu. Bagezaawo okujja wait Kyagulanyi gy'abataddeko bamulilivinga ffenna focus tuteyo ku Besigye. Tuve ku betwadde protestive vote. Bali tubadde ku protestive vote. Awo General Museveni atiddewo kati n'Australia ne wa Besigye n'abakulembeze bakiguddemu. Kati bagezaawo okumma Martha Karua. Certificate y'okuwolereza Dr. Kiiza Besigye nga lead council okufuna attention ya Uganda, attention ya East Africa, attention ya Africa na attention y'ensi yonna. Kyebaliko okuvibinga Besigye bamuteeke waggulu just muwachinge the space mulabe. Kanyaga tugende wano waliwo ekintu kya tribunal court martial tribunal martial awo waliwo katemba munene Lukwagoda agita tribunal bamala bagita court bamala bamuyita chairman bamala bamuyita judge ostegede kati waliwo katemba omungi nenjaga tugende master.
And with your permission, allow me to submit this document together with the response given by the Honorable Martha Karua. These documents, for record purposes, the response is here. Mr. Chairman, if you may, for record purposes. So the long and short of it, Mr. Chairman, as I sum up my submissions, the accused persons are still in the process of constituting their legal team, and this is what we are still dealing with. And it's an inalienable right, a non-derogable right under our constitution that they must be accorded the right to a fair hearing. They must be accorded the facilities to be able to adequately and effectively prepare their defense. So we are still at that stage, Mr. Chairman and honorable members. I beg to submit. So I will let my colleagues, Mr. Chairman, add on, because I mentioned the abduction of retired Major Iduli and a couple of other issues. I beg to submit, Mr. Chairman.
Thank you, Mr. Chairman and members of the Tribunal, the military tribunal. On the issue of where
Council Kiiza, if you read the UPDF Act, we don't have the word tribunal in the UPDF Act.
The English meaning of tribunal is court.
You read the Act, what does it, what is court under?
Judge, advocate, you are not supposed to exchange with me. You are not a member of the court. You should advise it and they tell me. You are not a member of the court. You are not a member of the court. You advise court and court rules.
Listen, my advice to this court is final.
Ulira obuyinza ulira amaanyi kitegeeza ono yalina obuyinza mu tribunal ono okusinga ne chairman tasalawo ono yasalawo era kitegeeza ono abeerawo kutiisatiisa chairman akyasalawo kyonna kiba kivuddemu ono ulira what my decision is final mama abasajja abeepanka
And section 2. We have rules of this court. It is not going to be like a political rally. In section 169 and section 212. We don't know about that.
I'm sorry about the interruption.
You wait till they read for you the law, because you may end up in the wrong hands of the law today.
Even you may end up there.
Just listen and they read for you.
Order, please.
But he's misleading the people.
Order.
order, please first listen to what the judge advocate is saying, and then we proceed. This is the court. I don't want to hear the word tribunal because it is not under the UPDF Act.
That is guidance that only comes from the court, members of the court, not from a judge advocate.
This is Kiiza, section 212, witnesses and advocates at military courts. And I will refer you to subsection 9. Any conduct of an advocate before unit disciplinary committee or court martial that would be liable to censure or be contempt of court if it took place before a civil court is likewise liable to ensure or is contempt of court in the case of a unit disciplinary committee or court martial, and the provisions governing the procedure of unit disciplinary committees or court martial are binding upon an advocate appearing before unit disciplinary committee or court martial, and willful disobedience of provisions shall, if perceived, be deemed to be in contempt of court, punishable in accordance with section 169. So, what section 169? Section 9. And section 169, offenses in respect of military courts. I take you to one thing. Any person who, being an advocate, conducts himself or herself in a manner described in section 212, subsection 9, will have committed an offense and is liable to conviction to imprisonment for a term not exceeding 5 years. So, as you address this court, I'm just giving you another warning that you must read the law. We are in court, we are not on a lorry.
Chair, with due respect to the provisions read, to the provisions read, those whatsoever he has read, he cannot in any way determine what we advocates for the defense say. We are not under his command, and no can he determine what court decides.
No, you can say it, but be orderly. You are not going to...
What counsel should say on our behalf, and we do not have that right.
So can I read to you the rules? I'm the judge advocate of this court, and I am the one responsible for making sure that everything moves on procedurally here. You cannot be a judge in your own court. That's why we report here.
The judge in this case, they are the investigator, arrester, prosecutor, judge. What are you talking about?
Where do you get those facts?
Do you want to surprise the facts of abduction? Do you?
So, Kiiza,
you want something?
Kiiza, you can go ahead and submit. I've given you the...
We are talking... can I have the mic? Before the mics don't work here. What is working here? Yes, thank you for the guidance that the defense lawyers are working. So, Honorable Chairman and members of this military tribunal, we have three issues which my senior land counsel alluded to, but I will start with the abduction because abduction is a derogation of Article 44, Paragraph C of the 1995 Ugandan Constitution. It is a sacrosanct right that should be not so. I'm not talking about the abduction of the accused persons from Kenya to Uganda and they are in concomitant incommunicado detention, which has resulted into this proceeding. What I'm talking about is that a member of our defense team, retired Major Iduri Ronald, has been abducted this morning towards 5 a.m. and he's not able to represent Dr. Kiiza Besigye and Haji Rutale Obiyed Kamlegia. And that means we are unable, our hands are tied, our team is incomplete. Even if it was complete, there's a lot to say about that, but we want to note that we feel that this is a form of intimidation on the legal team. The last time I appeared here in the morning, I found soldiers on my office. I ignored them because if they had touched me, I would have beaten them. But there are some members of this team who don't want an association with soldiers around their offices, around their homes. Major Iduri Ronald didn't open the door for them. They broke the door and he left the phone on and his siblings could hear the wreckage reminiscent of the abduction of Kapwenza, how it unfolded. So we hope this Honorable Military Tribunal can rein into the conduct of the military so that we don't have a repetition of this unfortunate development whereby a member of the Rotary and the Besigye defense team is arrested for precisely doing their work. If Iduri had not been arrested, he would be here with us and would be in a much better shape, including even on the knowledge of the rules. Because Iduri, I started practicing with him for this honorable military tribunal in 2014. I have been around. We started in Kasese, one in Kundubujo, one in Jinja, and I'm an old hand at this. We have 3 visiting jurists.
Now, why would a lawyer be abducted? Because he's a former army officer who knows better what this military tribunal is doing. Ebintu bino tebina kugatta bulungi. Kati bamukwata Besigye ne bamuleta. Bagala bamuwolereze tebagala kumuwolereza. Government yagala Besigye ateebwe oba teyagala ateebwe. Bo bannamateeka be baagala Besigye ateebwe oba tebaagala ateebwe. Ye Besigye ayagala ateebwe batagala ateebwe. Kati kyonna kituzaayo. Why was this done? Lwaki Besigye yali abducted? Lwaki bamuwambira Kenya ne bamukomyawo wano? Bino byonna okugenda mu maaso waliwo olukwe olugatte oluli mu kutambula lw'omutanda bakugwamu bannayuganda naye nga mwetegereze Katemba mujja kulaba ajja kuggweera.
but her right as senior counsel to sit on the bar is untouchable. Then the seating arrangement, your Honorable Chairman and members of this military tribunal, we are unable to proceed with any further when our colleagues are standing, because there is no way we can proceed in this fashion. We pray that this honorable court sorts the seating arrangement of our colleagues before, as a defense, we can proceed any further. Thank you.
Mr. Chairman, for record purposes, my name is Besigye Gaslighted. I rise to express our displeasure as regards the manner we have been treated at the entrance. When we enter here in these premises, we are supposed to be officers of court, and we should be treated as such. However, after here, we go back when we don't need any further gym, any further work. After here, we are so tired. As we talk now, we are extremely tired because of the mistreatment. The soldiers take us through. This should be changed. Indeed, there is nothing which resembles a court, depending on the conduct of the soldiers out there. Mr. Chairman, it is my humble request that this honorable tribunal benchmarks with the other courts, allow us the permission to treat it as a court. Indeed, the way we are treated, we are right to say that we and our clients are being persecuted. Our clients are not being prosecuted, but rather persecuted. Your soldiers out there are determining who to lead us, where to sit, who speak what. Indeed, we are not grateful with that kind of treatment. This is not what is done in the courts of judicature. Something must be done, Mr. Chairman. As you lead by example, that example must be seen. That is the motto. By example, we lead. That is the UPDF motto. But sincerely, there is nothing to emulate from the conduct of soldiers out there, treating us as if we are criminals, or as if we are convicts. We are not. We are good people, and we love you guys. We love you, soldiers. Don't treat us like that. Tukoye. Okay. Thank
you. Kiri mu tribunal. Nange nzikiriziganya nabo. Uganda tena kujiberamu na mirembe. Ati bagamba nti UPDF yekulembera ekifaananyi irage ekifaananyi kya Uganda. Okitegedde. Ke kabonera ke nkunala akalaga Uganda kikyeki. Kati bwe bange okola ebyo kitegeeza Uganda nfu. Nange nzikiriza nabo.
Honorable Chairman, and can I speak? Can I speak? Referee, what's your problem?
They have asked the lawyers for not Kiiza Error.
I'm requesting to speak. I'm not imposing on myself. No, have you suddenly become a court referee?
We want an answer from
Mr. Chairman, I request to be respect the rules regulating court processes. When an advocate is instructed, they have a right to audience. Each of us here were instructed instructed to represent the accused persons. So even if all the 40 were to speak, they breach no law. So I kindly and humbly request the judge advocate to hold the fire.
No, the issue is we want to know who filed the practice certificate with the registrar.
But the thing is, we have put the names on record. We want those who are supposed to have audience.
We want the practice certificate of whoever advocate appearing here. And it is done in the
Order, please. Honorable Alukwago, I wanted to talk about that in my small communication here. When you talked of sitting arrangement, from what the registrar has, he told us 10 people who have fulfilled the requirement. And that's why the arrangement is like that. We expected 10 people, and those who have not fulfilled to be in the seats held there. Why? First of all, Councillor Babu, you are self. You did what you are supposed to do. Others did not do it. Now, what is that? How? Why is it like that? Why is it like that? So Judge Advocate was asking the registrar to update the code. How many people or who are they who fulfill the requirements? Can you please tell us that?
In prayer, in arrest of that ruling of the Registrar General's thing, reading of the list, because there is a constitutional matter now at play, the right to a fair hearing. The last time I checked, Uganda was being governed by a constitution. In section 2 of that article 2 of that constitution, it was binding on all authorities, all persons, including the judge advocate, including this court, every member, and it is to the effect of that constitution that the right to a fair hearing is sacrosanct. That right to a fair hearing includes the accused persons, in this case our clients, choosing their lawyers, the number of the lawyers, and even now as we speak they can add on the number of lawyers. It is not the province of any court in any land, not even the Supreme Court can tell the accused.
Council Kiiza, we are not limiting anybody. We are just talking about the procedure.
I am trying to say that that procedure, to the extent that it tries to stop Besigye from hiring a new lawyer right now and submitting it before you, is null and void. And the solution to such a null and void notices is in several provisions of the Constitution. There is 274, and another is 1262. The 1262 says that substantive justice, and there is now justice more substantive than the right of the lawyer, the right of an accused to choose their lawyer. And that right, when I say it is sacrosanct, I mean it cannot be modified by anyone, not even the President of the Republic of Uganda can modify the right to a fair hearing. Right now, even as we are speaking, we can substitute counsel. As we speak, we can get a new counsel. So the idea of 48-hour notice, we reject it as null and void. Family, we are not. The fact that me and Rukwago brought a notice does not mean that we are amending the constitution of the Uganda. That was a bonus, and since the accused have since added on the lawyers, and no one can tell the accused which lawyers to appear today. That's why we are unable to proceed without our colleagues.
Mr. Chairman, if I can proceed. Maybe if the issue before this tribunal is about whether one qualifies to be an advocate and to have audience before you, it should be clear, and I have my practicing certificate with me here. I can provide it to this court. Two, I raised on an issue that is very clear. Under the Constitution, the formation of the UPDF. And Article 208, I will go to 2, that the Uganda People's Defense Forces shall be non-partisan, national in character, patriotic, professional, disciplined, productive, and subordinate to the civilian authority as established under this constitution. We form part of the civilians, Mr. Chairman of the Tribunal. 2, clause 3 is that the members of the Uganda People's Defense Forces shall be citizens of Uganda and of good character. Mr. Chairman and your Tribunal, the character depicted by the members at your entrance there is not of good character. Secondly, I can see you have your name tags on your uniforms.
I think those issues, I don't think that's why we are here. First of all, we are sorting out the issue of advocates.
Yes,
Honorable Kwago said people are standing. You are going taking us astray.
Advocate Judge, let me address my issue, then you can respond.
No, because that issue,
because this is a very sensitive issue.
Councillor has talked about it.
With all due respect, my issue is a different issue. It's about identification of the people that you put at the center as we enter. You can't know who manhandled me, who battered me, and you should act as good examples to the rest of the people. You are people with superior powers to guide the professionalism and conduct of the people. Why can't that be so that we know who is addressing us and at what time by putting on their name tags on their name? Thank you.
Council, you have heard about the conduct.
Kyendabamu mono katemba ina nti kigenda gogola tribunal y'amagye ne bannamagye abadde batulugunyizibwa kibayamba kitereeza okitegedde kigenda kubayamba badde batulugunyizibwa nga tebalina bwogerero basajja battu naye kino ate kigenda kiinako kale a bit of benefit kiinako ekirungi kyekigenda okuvaamu kuba kati worldwide ensi yonna eraba ate bali mu kutereeza boogera ku nsobi eziri mu kino ekintu banaaswala ojja kukola ne bannamagye badde batulugunyizibwa mu kooti mu tribunal eno nga bayisibwanga ebyonzira nga kigenze kitereera we are sanitizing Uganda naye nga Katemba waali.
And I have heard from your side, I will interact with those people at the gate who are manning the security. I believe that one will be solved.
Registrar still, you have said you have your PC. I don't think anybody is going to put on a suit and a tie and come here and serve a lawyer. So we are going to prove that by a PC. If you don't have a PC filed with the registrar, we shall not recognize you in this court.
Mr. Chairman, we take exception. Lawyers are certified to appear in any court once they are on record. So if you are in doubt whether one has got a PC, that can always be addressed. But it's not that every time we come here, we brandish our PCs. Here it is, here it is, here it is.
Council, we have not asked you. There are those who have not submitted.
Let's enter the issue. So there is what we call a digital system and the court. Even if you want to know the lawyers who are entitled to practice, you can Google them. The Uganda Law Society website. They are public, are available. That should not be a problem. It's not a problem of their choosing. I think whoever is trying to create that problem should deal with it, but the accused has chosen competent lawyers, and whoever is in doubt of their qualifications should Google them.
And for any doubt, they can proceed to the law council for those
ebintu bya Google.
who gives us license should write to the legitimate The names are available. They were available 3 times on the gate as we are being searched, as we are entering this courtroom. So we cannot provide several times. How many times are we going to provide? The ball is in your tribunal. Then the answer would have been with the judge advocate saying, I have scrutinized with the chief registrar by the letter, and the letter, the list is submitted saying this one and this one are not enrolled at. That would not so simple. It is not him suggesting it's an attack because he does not fall in the wrong language. He does not.
I don't hold it, but I am moving under the regulations governing the court.
Not the certifying authority to certify whether somebody is ready or not.
Anyway, the matter is simple, and my guidance is final. I'm telling you, you have to file your pieces with the register. That's it. Mr. Chairman, here the pronouncement of that, whether the interpretation by the judge advocate is final and is binding on all this court and on all of us, whether it is ill-advised or not, whether it is misconceived or not, we need to get a position on that. Because otherwise that will be violation of the principles of fair hearing. Because we are to be heard by the court. And the decision made.
For avoidance of doubt, we do not need to hear from the chairman to know that the judge advocate is misleading court. The primary character, the defining feature of any tribunal, including quasi-judicial tribunals, is judicial independence. If a tribunal is telling us that it is not independent, that whatever the judge advocate says, they will swallow it, hook, line, and sinker, then we have no business here.
The word tribunal, we don't have a tribunal here.
I don't know how many times I will tell you that this is a military tribunal. There is a dictionary, you can look it up. The meaning of tribunal. I'm getting tired.
Council Chiefs, I think, Council Kwabo, we are not doing this honestly. Because I don't see what harm does it make you to follow the procedure and bring your PC and instructions to registrar so that we know people we are dealing with. What's wrong with that? Why do we waste time on this?
Because, Honorable Chairman, we have put it in black and white. We have put ink to paper. We have.
And you are tasking court to find out, to go on Google and find out whether you are practicing or doing what.
In the cases, just a minute. In the cases where we want to,
came from.
So, Chairman, in the cases where the court doesn't want to Google, they formally write to the chief registrar of the courts of judicature, and the chief registrar writes back indicating that this person is not enrolled or licensed for this year, or he is. That is how the procedure for courts that was there sort of to do.
You talked of Major who was arrested or
abducted. Retired Major Iduri was abducted a few minutes towards 5 a.m. this morning by members of the joint security team, including the military, to which this military tribunal belongs. And that's why we are using the good offices.
It's good you know who arrested him. I think you can either approach them or pressurize them to produce him to court so that you can start from there. Otherwise,
our complaint, Your Honor, is that Mr. Chairman, is that he is a member of the defense team. The reason this team is incomplete is because he has been abducted by members of UPDF.
And that's what I'm saying. It's good you know who arrested them.
members of UPDF, I think there are many departments. I don't know who arrested him. Is it the court or is it the who arrested?
It's not the court.
Who are
They are like the ones we met there without tags. The guys we met at the gate, they are also like them. They are without tags. Some of them are. It's a nasty situation. They want when abduction is terrible.
Since you know them, that's what you can handle.
We are military strangers. We just know they are military men, but they are not identifiable.
If he's brought here, then we will listen. And
ya solution ya jawadde nti gobawambye gobabuza omunamateeka wa Besigye bwabanga tabasobola ku identifying baani bamuwambye then balindeko bw'anaaleeta wano bajja kuwuliriza ensonga eyo ye Uganda yammwe ne General Museveni.
Councillor Kwago, you again talked about the lead council, Madame Karua, I think, who is not cleared. Who is not cleared by the Law Council, according to the document you have presented here. So before she's not cleared, I don't know what you have. Can you read the team or not?
Chair and honorable members, I unequivocally stated that the prerogative rests with the accused person to choose who is the team. But from the instructions we got from council here, the law council, if I may read page 3 of page 6, paragraph G, the law council is composed of members who have full-time jobs in other government agencies and as private practitioners. They require adequate notice in order to meet and consider applications. We believe they have not had ample time to canvass all the issues they needed to deal with, given that statement. So it would be premature for any decision to be taken at this stage before we exhaust all these processes. We believe the Law Council, in making that statement, they wanted to get more time to deal with this. Never mind that they indicated some issues which we find objectionable, like the political connotations and other matters, which we can put squarely to them. And as I indicated earlier, Chairman, the Honorable Martha Karua has made a strong rebuttal to all the issues that have been raised here, which has been served on the Law Council. We are yet to be favored by a response. We believe now that there is a rebuttal and the issues they were raising have been adequately responded to. They are going to reconvene and take an appropriate decision. So this is, we are saying, on the understanding that the accused persons have got a right to constitute a legal team to defend them. The right to legal representation is sacrosanct, is non-derogable. That is the whole point. And they want to have an effective team. And these are not the usual proceedings we have, Mr. Chairman. Because if it was just an ordinary case where you are trying a matter which does not cut across different jurisdictions, Mr. Chairman, the charge sheet is very clear. The accused were picked from a totally different jurisdiction, Kenya. And we were brought here without going through the due process, without an extradition order, without a deportation order. So the jurisdiction where they are picked from is where you are having the senior counsel coming from. And that is the reason we find strange the reasoning advanced by the law council that they don't expect any special skill the senior counsel is going to bring onto this matter. Maybe they were oblivious of these facts, but now that there is a rebuttal, we are confident that they are going to reconsider this matter. So I cannot arrogate myself the duty of leading counsel when the instructions are on the contract. I thank you, Mr. Chairman.
Okay, it's okay, counsel. If that process is finalized, for us we are here. So you, as if you wanted to say anything? Somebody wants to say something.
I will not forget, but from my when you look at our colleagues, how they are conducting themselves before this court, and when they are now confronting those young boys, what do you expect? If they can behave the way they are behaving,
There's a hand here.
those small boys
There's a hand here.
must change. Then my prayer, this court is that which actually said what court happened.
Ne Katemba ali wano neno yose mujja tuteyo Katemba we Katemba gwagala naye mu parliament neno mu tribunal mututteyo okumanya Katemba ali wano mungi era ayagala alage ekisaati ky'ekibiina kyabwe kino ki alo Uganda ekiri eno ewa Besigye kweraga tinange wendi nange mwembiri munengedde ngwendi nnyo nnyo mundabiranga ddala ab'ekira
And discussing the merits of this case. This court has no jurisdiction. The charge sheet is from the other. I think I should respond by this. Matters before court discussed. And I've seen it several times, including Aaron Kiiza, who is referring to this court as criminals. My understanding of
can I substantiate myself? No, it is you sit down. When I write, if you are a lawyer who went to law school, sit down, don't waste our time. If I stand up, you sit. It's automatic. So, no, that is okay. Then you need the land before you. No.
When they were talking,
You see, when a lawyer stands up, you sit automatically. You didn't learn that in school.
Council Chiefs, I want you to be patient. Submit and then you are given time.
You don't just mention every cheese of God. Stay it up. Stay it up.
Council Chiefs.
Yes, I'm possessed of wisdom and knowledge. Yes. Yes, I'm possessed. I'm happy to recognize it.
Chiefs, can you listen?
Council, you know where you are supposed to take your grievances. Why do you take them to the public? No, I'm why do you take these complaints to the public? Why do, if you are not agree with the matter, you know you are supposed to go to another court. The other time you appeared here, you first made press-ups outside the court. Were you taught the 5 years we're talking about? Were you taught that we must first make press-ups before you go to court? And by your standing to the you are supposed to take a shower. You come to the constitution, you say it was a parliament. So, yes, right after those actions that you are doing, come when you are proposing and when you are prepared to proceed with the matter. So, I pray that these people be restrained from talking about the matter which is before God. You can see some women. I can really recognize some revered lawyers. I've not had him talking, and I think he's waiting for evidence. But some people come here just to make a show. Ernest Karibara, you see him. He's a respected lawyer. I've not seen him making any noise. No, he's waiting for evidence. So I pray that these lawyers be restrained from discussing the matters, especially touching evidence. So if you go with the church to the public, so what will the public do? They are going to that has to be the direction. So in regard to my question, I wanted to be at this saying this person was abducted. No, we are having the person before here who was abducted. There is this African protocol allows us to enter into various arrangements and engagements. And among those engagements, there is a memorandum of understanding between the Republic of Uganda and the Republic of Kenya on cooperation in defense and security matters. And under that arrangement, it is where we have the two accused persons before this court. There is a paragraph. What are you objecting?
I am objecting to your honor. We are not yet at that point. So the issues by counsel. Please. There is no disclosure of what you're stating.
No. It is a memorandum.
Let us stop wasting our time.
Not waste our time by
Don't waste our time. Don't waste our time. Either you share it or you sit down. No, we need a copy. We need a copy of that notice.
we are objecting to your conduct.
Look at how you are conducting. So I will say that
Uganda enyuma Katemba ali mu kooti eno. Kasita luupu wange gyali Joel Ssenyonyi. Tatambule. Finita ani amulengedde. Finito.
I hope you have come submission on that particular matter. Because there is a wealth of authorities on the rule of sub judice, and he has not cited any of the authorities or the principle or anything. But if I may help him on this, the rule of sub judice, Mr. Chairman, is not absolute. It's structured in such a way that one shall not discuss a matter which is before court in a manner that is likely to prejudice the outcome of the case. It is qualified in a manner that is likely to prejudice the outcome of the case. That is one. Two, to discuss a matter which is before a court of competent record, a court of judicature. If matters are before a disciplinary committee, for example, they are before a tribunal, they are before an LC court. I'm not suggesting this is one. I request you take it in good faith, Mr. Chairman. I'm just giving an example. So the rule of sub judice is not of universal application. It's about courts of judicature. So if it's a matter which is before the General Court Martial, which is not a court of judicature, which is not a court of competent record, he ought to have come there with the authorities to stretch the application of that rule to the proceedings here. And I make those submissions well advised that they are good authorities to that effect. We're not expecting him to raise it. But that said, Mr. Chairman, again, the rule does not bar anyone, not even advocates, not even members of the public, to discuss decided cases. He talked about our continued pronouncement of the trial of civilians before the General Court Martial. There is a court decision to that effect. So it's not a matter which is sub judice, whether civilians should be tried before a General Court Martial or not. It's a decided matter. If he interested himself in a decision of Kabasburuka, a copy of which Council Tugume can show him, we have a very big decision. It is there, a huge one, about that. So if we are interpreting a decision of the Constitutional Court, we are not breaching any rule of sub judice. I am at liberty at any given moment, any given time, any given forum to interpret the decision of the Constitutional Court. I breach no law. What is pending before the Supreme Court is the appeal. So if I make a demand that the Chief Justice should render a decision which has been long overdue, with the commitment that was made in a ruling that I can share with you, I have a copy here, Mr. Chairman. Get me a copy. I am breaching no rule whatsoever. So if I read out, and these are things, these are matters we have said time and again on media and elsewhere. And this ruling here, Mr. Chairman, in the Attorney General versus Honorable Michael Kabasburuka, the Right Honorable Chief Justice here and the justices of the Supreme Court, in decision number 4, they said, owing to the matter in contention for which the appeal has now been filed, being one of great public importance, the appeal shall be accorded urgency and shall be immediately fixed for hearing, dated 5th August 2021. So, Mr. Chairman, when we stand out in the public and demand that the Chief Justice should honor the dictate of this ruling, the decision they made
that this appeal should be disposed of expeditiously, we are actually asserting the rights of Ugandans in the Bill of Rights in Chapter 4. Because matters touching the Constitution, matters touching personal liberties, rights, take a precedence over any other matter. So these are the issues we have been discussing. And by now, the point I wanted to emphasize, the position of court now, which has not been set aside, and which we can freely discuss, is that this honorable court has no jurisdiction to try civilians. That is the decision of the Procedural court, which has not been set aside. So if I repeat it, I'm breaching no law, and no court can stop me from saying that. So that is as far as that issue is concerned. The other issue is talking about, and the last one, is about, again, matters in the public domain. Mr. Chairman, we are really shocked that the prosecutor here is talking about the defense when indeed actually the application should be in regard to the state. The application to restrain any of the parties in this, indulging in the merits of the matter, actually that order should be directed to the state. Why? Because they have already started trying this matter in the court of public opinion. Getting audio clips, which are purportedly said to be emanating from UPDF, being even transcribed verbatim in one of the dailies here and a number of other media houses. This is prejudicial to this matter. Actually, it is choreographed to condition the public out there and the international community that these accused persons here stand guilty. Contrary to the foundation of our constitution that thou shalt not be treated as a convict until proved otherwise. Now the state is already trying them in the court of public opinion. And he has not come out to condemn that and to ask any application for court to restrain them. What a shame. So, Mr. Chairman, I want to conclude by asking that those issues he's raising shouldn't be entertained. Here, what needs to be done at this material time is for us to have the team of lawyers, because we are still considering preliminary matters. Those are the preliminary matters we raised. We want to constitute our team fully and be able to proceed with the matter as and when we are ready to proceed. So I beg, Mr. Chairman, that the application he has raised, and to me in particular, you see, he mentioned my name, and I wish he cited anywhere where I featured and offended the rules, but that is besides the point. But if I may also ask him, as I conclude, Mr. Chairman, is he asking for orders to restrain debate worldwide? Because this matter is not only restricted to the confines of Uganda. It is on CNN, on Al Jazeera, on AFP, on KKNT, it is everywhere being discussed. So, of what I don't know, the confines of the orders, whether this General Court Martial has got orders to order the world never to talk about Dr. Besigye case until a decision is rendered. So that would be really outrageous with all due respect. It would be absurd and it shouldn't be entertained. I beg to move, Mr. Chairman.
I will be very pithy, and I like the wandering Jew that raised these matters. One, media has media freedom. We are not going to discuss it. If people didn't understand it, it's too late. Pastors, going to a pastor is a function of religious freedom. It is outlined in the Constitution. It's a human rights in the line. Going to witchcraft, if I wanted witchcraft, I would have gone to Raphael. I didn't. Where to take grievances, yes, I know. Press-ups, I want to be healthy. I don't want to look like some people. profession, yes, I'm an honorary member of the profession, and on civil society, the Uganda Law Society has recognized me. About rhetoric, now we can't get into poetry. We are here to discuss law. So I still leave the rhetoric to him. The word promulgated means bringing into effect. Laws are promulgated. I don't know what I mean, I am not responsible for the inability of the prosecutor to understand what I'm saying. I am not responsible. There are some things that on prayers of restraint, that one are not dignified with the comment. On prejudice, he needs to address himself to Article 29 of the Constitution before he submits on prejudice. He hasn't. Has he? No. The charge sheet, yes, it is a public document because there is an assumption that a quasi-tribunal is a public body whose documents can be shared. We shall continue sharing charge sheets in WhatsApp, with media, on my Twitter, it's even there. You will not remove it. And we shall debate it. Abduction, it is a fact, you can't try for it. You abducted. The people here, these two people are a product of extraterritorial abduction and extraordinary rendition. Those are the English terms. If any breakdown is needed, I am ready. These are victims of abduction, of heinous kidnapping. They are here because some soldiers committed crime in Kenya on 16th of November. Those soldiers have not been brought to book, and tomorrow I'm going to write to the CDF to give me names of the criminals who brought Besigye and Rotary here in the breach of Kenyan law, of Ugandan law, and East African Community law, and the African Charter on Human and People's Rights, and the Universal Declaration of Human Rights, and the International Covenant on Civil and Political Rights, on the Convention Against Torture, and other legal instruments. Raphael will not stop that. That's the discussion between me and the CDF. It's above him. Kidnap, abduction are crimes under the laws of Uganda. No member worth his soul, no citizen of Uganda should be here to drum support for kidnap and abduction. The duty of anyone who has witnessed abduction or in detention is to report to police or appropriate authorities. This should be the last time that someone is raising with this court in this matter tribunal to support abduction. We should all condemn it. The memoranda he was trying to read is a secret. There is no law which is secret. Laws must be gazetted. Whatever you're reading is null and void. So, yeah, indeed, these are older men. The last time I checked, Besigye was around 68. Rotary was crossing nearby. So if you are going to hold old men standing for these hours as lawyers urge the law, or what looks like law, it's going to be unfortunate. I mean, what looks like in the case of Raphael. It is also unjust. And just that our colleagues we have raised it, we are unable to proceed further because we cannot proceed when our colleagues have nowhere to sit. It vindicates those who say that this is a kangaroo court. Kangaroo means unfair in case someone doesn't understand it, and I know who will not understand it.
I don't have ended my submission. Mr. Chairman, the prosecutor is inviting you to restrain our freedom of speech without any evidence, without any justification, without any basis. He is blackmailing us, Mr. Chairman. I believe you have heard from his statements attacking even our conduct from outside this tribunal, Mr. Chairman. For instance, when he cited the press-ups which were made by my learned friend. Mr. Chairman, I invite this tribunal to treat his submissions as mere statements from the bar. The same should be disregarded as being without procedural or evidential value. Mr. Chairman, overrule the prosecutor. Mr. Chairman, don't grant the orders he's seeking. Mr. Chairman, the prosecutor is inviting you to infringe the provisions of the Constitution. Mr. Chairman, you and your tribunal must uphold the provisions of the Constitution. Mr. Chairman, we are not at that level where we may be considered to have moved against the principle of res sub judice. Mr. Chairman, I beg that you disregard all the prayers made by the prosecutor. I beg to rest.
Mr. Chairman, with all due respect to the state here, I made a comment about the discipline and how we are mistreated at the entrance. And he claims that it is because of our conduct, which is not clear. We are told to identify ourselves. We do identify ourselves before we access these premises. This is a public court. As we speak now, you can look at the men here in uniform, without name tags, even when the space is provided for. We are here, they have introduced ourselves as, you have name tags on your uniforms, why are they here? Our security here should be paramount as a public place. That should not be an issue of Councillor Five discussing. It should be clear and good. With all its powers, the tribunal, through you, Mr. Chairman, you should make that order and directive, and it should be complied with, so that we ensure that we are secure and safe even when we are speaking in this. Thank you.
You are very secure, Council.
Ne okimanyi nti ono chairman talina buyinza mwene kooti just alwokuwuliriza buliriza abasalawo yoli boy atudde wali agambye my order is final ne kati bamuovaluulinze bano bakanso bamuovaluulinze babyemu ebituli kati atandise nayo kukankana empale kati ono chairman okuba kutegeeza kubuuza oli do you have anything kati naye agamba byenjogedde ngeza okutiisatiisa biganye abasajja banswaziza mu bwana bw'amagye kati sikyalinamu katiibwa kati ne bali abasirikale banyumira bajja gamba abasajja babookeza abasajja babadafuyiza kati basobeddwe kale mu kibira ebibakalidde ku matama nakuba bali ku order ya General Kaguta Museveni bakola kino kyebakola basajja batu nabo tebalina musango kyobulanzi Lumumba saasira tebalina musango bakitawe naye bali ku order ya General Museveni nti balina okukola kino kyebakola naye bijja kuggwa anytime bijja kuggwa Uganda ffe ejja kutereera.
My Lord Chairman, honorable board members, we have a brief rejoinder, especially what was raised by Land Council, Mr. Rukwagu. My Lord Chairman, as far as the jurisdiction of this court is concerned, my Lord Chairman, also we rely on the Supreme Court.
Have respect for counsel on the other side. If there is an objection, you should listen.
Joseph
Please
Musabe
objection.
against.
Please sit down. We are raising on a matter of objection. You know the procedure.
It's a 2005 decision.
Objection. Objection. Please sit down.
Chairman,
Sit down. Sit down. Sit down.
Much obliged, Madam Chairman. I was saying that we arrived at the decision of Kiiza Joseph against the adjournment. 2005 decision in as far as
You wanted the Kabazuka. He also has the right to contact the
much obliged.
in regard to the issue of sub-duties.
And Madam Chairman, with due respect to my senior colleague, I pray that please restrain because I wouldn't want to exchange with my senior. I have a little respect for him. But as may, my Lord Chairman, I was submitting that one, we ran that decision of the Supreme Court that Kiiza Joseph was the 2005 decision in as far as pronouncing itself on this court. But also, my Lord Chairman, on the decision of Kabasikuka, Chairman, we have a ruling which I
Please stop taking us on a wayward point to self-delusion.
and my Lord Chairman, if I may read verbatim. As part of the ruling
amazima agali mu mateeka munnamateeka bw'oba oyogera muno naanyumya n'akola objection ku byoyogera osirika n'otula n'awa submission ye naye bano bo bagala kulagaye ekirimaanyi ffe twetooloddwa mu mundu wano twambadde ebyambalo by'amagye temutugambako kino wadde katemba ne waliwo kye kigenda okutereeza bayagadde okukola katemba waabwe n'ate kigenda kubanaliza nga kibalidde nga kibatuddemu gavumenti yennyini nga kigituddemu ne tribunal yaayo balowoozeza nti nno byakola katemba naye ate mulimu abaana abatafiirwa nze seegoli ya seegoda bagamba ffenna tukifiirwe Neka mbuuze nzikirwa nga finito munnamateeka ye nga tali ku bannamateeka atudde wali emabega asirise finito akola ki yandibadde munnamateeka naye ne tutya erugamba finito waffe yoyo maama
Our defense team is not fully constituted. So we have no instructions to proceed in respect of the substance of this matter until when our defense team is fully constituted, Mr. Chairman. All we can seek is to have maybe this
concerning this matter. If the prosecutors withdraw their charges against our clients, we have no problem. We shall oblige, Mr. Chairman. I thank you, but we cannot continue discussing or submitting on the substance of this matter. It's premature. I thank you, Mr. Chairman.
So you raised discussing court matters in media. Then the council submitted, and I don't know what if state that's what you are going to make a rejoinder of.
Yes,
On
that's
that one, so that court can rule on that.
Was about the application was making, just paying us to debate this matter in public. And we responded adequately. Now he's raising new matters which were never covered in the application, and for which we have no capacity as materials to handle before we deal with the question of representation. Yes, that's what we want to discuss.
So state if you are making a
He's
rejoinder
the one
of that one.
who raised the issue of Kawazuruka. We have not talked about
Make a rejoinder the objection.
Mr. Chairman, before he makes a rejoinder, whatever, we need to sort out, we need to sort out the issue of representation before we go any further, because we have no instructions to proceed beyond this point.
Sir, can the state pray for the debt? And we have the matter adjourned because they are saying we are not ready to proceed. Council, do you have a debt or state? A debt, yes. That you propose a debt.
Can we have it mentioned in this time? This time we go and pursue our matters.
Kiri mu kooti Masolo. Kooti Masolo oba Tribunal Masolo. Ne omanyi nti side zino zonna tekuli side erirwedde kugenda mu maaso na musango guno. Omuwambe Dr. Kiiza Besigye ne munne tebalirwedde genda mu maaso na musango guno tewaba bawe beyiro. Bakyanyumirwayo gye bali ndowooza. Abalooya bannamateeka ndowooza balina instructions okuva ewa mukama wa Dr. Kiiza Besigye nti tetukkiriza musango kugenda maaso tubeeraawo bwe tutyo.
Having seen the dilemma we find ourselves in, all the way from judge advocate, senior prosecutor, and what the defense is going through. I want to apply to the amicus curiae this matter. Because there are some constitutional issues and human rights issues, and it is on that basis that court can admit us to be amicus curiae, so that we can resolve the unwarranted procedural issues that are engaging us wantonly at this moment. I pray.
Honorable Chairman, we cannot respond to that, and we are not interested in any ruling on that. For us, we have no instructions to proceed on anything before we conclude the issue of representation, whereby our lead counsel must be Martha Karua from Kenya.
We then reject the application of having amicus curiae.
Your Honor, my Lord, we cannot proceed without, not even with objections. We need the issue of representation sorted out first. They are choosing to have a right to fair hearing. We pray for... Chairman, we are praying for 1 week from now.
The case is a state case. They are the ones to apply for a date.
I do believe when you are given 1 week, we pray that the case will be adjourned. Instead, we will be 1 week. 7th January.
And also, we have processes to pursue before the law council, involving the council here and the others, so that we have them expedited and come back in the 17th. We move on to another stage. So we talk of 7th January. I think our land friend here wants early Christmas.
No, Council, I think let's give you enough time because it seems whenever you come, now you come to the other extreme. Get enough time, prepare yourselves, and then we proceed. I think 7th January is enough. Huh? Is that Kano retired Dr. Kiiza and your colleague, your case is adjourned to 7th January 2025 for further mention. The same time. 10.
What?
kino ekikoleddwa just to restrain them, kubatiisa.
We shall overcome. We shall overcome. We shall overcome someday. Deep in my heart, I do believe we shall overcome someday. We shall live in peace. We shall live in peace. We shall live in peace. We shall live in peace someday.
Take some 5 minutes to get some pictures. Thank you so much.
Uganda onyumirwa bwoseka bwokaawa. I don't know, simanyi mumukirawa mutya kuba nze mbadde sirabangako mu zino tribunal z'amagye okubanga bakubiramu embeekuulo. We shall overcome, Museveni will die, Museveni is dying. Ate mbaali mu bintu bya Besigye ne Museveni babayisaawo kaki ne kanagguka. Bannayuganda muŋŋambe kanagguka mumulaba akantu kabwe kanagguka ke bayisaawo gye ne Museveni ne Besigye. Kayinza okugguka kuba ndaba tension bali batandise ogifuna. Kati babyongezaayo nga 17 Jan. byongera okufuna vibe vibe katugirinde. Byonna binaaba bitambudde tujja kuba tubibawa mu birabe mu bitegeere naye nga nsaba twetegeerere fe obwongo waffe tubuggule tutegeere ensonga tuzimanye tuanalyzinge for ourselves tumanye nti nno tulina okwesalirawo tulina okwerowooleza ensonga zino tunula wuliriza laba buli ekigenda mu maaso buli ekitambula gambe naye kino kyandigwanidde okuba bwekiti ddala kyandibadde bwekiti amazima ddala oba kisibe kyandibadde kaki ke bayisaawo kaki ke batambuza bino ebintu tunaagenda okuzuukuka nga waliwo ekintu kye batuyisizzaako eky'amaanyi nga waliwo kye bali mu kuyisaawo ekinene nga situkiwadde budde nsaba tuwa ebintu buno obudde tubyetegereze. Martha Karua Lead Counsel bamumye ebiwandiiko ebiwoza omusango. Besigye talina instructions mufuula Lead Counsel wabula kwogeramu ku bwogezi.
We proceed. We are just going to have brief remarks from our lead counsel, lead of opposition, and the gentleman to hear briefly about the proceedings today. But all I can tell you, we are glad that we are united more than ever before to deal with the madness here at the General Court Martial. You can see this is a real kangaroo court. These are not proceedings of a court of law. You can see the environment is not conducive for dispensation of justice. Whatever is happening here, we have said before and we want to repeat it, is a travesty of justice, it's a mockery of justice, it's a violation of our constitution and all international instruments regarding fair trial, fair hearing and administration of justice. The team from across Africa, we are very, very much appreciative and we are determined to push for the clearance of all the lawyers coming from other jurisdictions to beef up our team. They wanted to frustrate us, to suffocate the process, to stop the Honorable Martha Karua here from leading the team. But we are determined, as you witnessed today, we insisted the proceedings will not continue unless the lead counsel has been cleared. From here, we are going to design more. We are retreating back. After here, we are retreating back as a team and leaders to work out and weave out other measures of ensuring that we get our lead counsel cleared. The law council must understand one thing. This is East Africa. The law council must understand one thing. Dr. Besigye and Obed have got a right to legal representation to get lawyers of their choice, and this is a non-derogable right under the Constitution. We are not changing the position. The lead counsel is Martha Karua. She will continue to lead us until we get justice. That is it.
no retreat, no surrender. Thank you. Allow nga bwe mulabye ebigenda maaso wano gye bayita katemba mu kooti siwali bwenkanya mubalabye abalamuzi bwe batudde eri ng'abalamuzi naye eyeefudde judge advocate ye yeeyitanga omulamuzi atuuse n'agamba n'ogamba ye kyasalawo kyekisembayo. In fact judge advocate ye mulamuzi n'oli prosecutor atuuse n'okugamba abo bonna mubagambe tebaddamu n'okwogera ku musango tebakola ki kwegamba ng'olaba nti kooti si kooti naye kangalu. Naye tuli bamativu nti tuli wamu ng'ekitole nga bwe mutulabye wano. Jo statement eyakoleddwa tugyeyanza nnyo nga tiimu ekulembeddemu leader of opposition wano ng'ekulembeddwa mu leadership ya NUP n'abakulembeze abalala jeno baani bonna ffenna abali wano. Naye tiimu eyavudde ebweru ey'abannamateeka tugyeyanziza nnyo. Olwaleero Martha Karua ali wano tugambye kooti nti ya Dr. Besigye n'Obed be balina right mu ssemateeka okusalawo ani akulembera tiimu. Tetulina liida mulala. Omukulembeze waffe akulembera ligo tiimu eno kapiteeni waffe ye Honorable Martha Karua. Tweyanza nnyo ne Nana Kovi all the way from Angola ne council from Kenya n'abalala abagenda okujja era tugenda kati mu law council okwatagana ne law council twagala law society ne agencies endala zonna zituyambeko. Tulina okufuna certificate ya Martha Karua mu mbeera yonna omusango guno okugenda maaso kubanga ye lead council waffe ate era nga n'emisango bagamba pisto bazisanga ne Dr. Besigye mu Kenya bagamba bagidiza Athens Ruda olwaki ogoba baleera abaava ebweru nga Dr. Besigye wamukwatira bweru. Ekyo tetujja kukikkiriza. Kasabe leader of opposition ajja kutubaayo statement geno muntu then lead council akurowning up.
Okay, today, 10th December is International Human Rights Day. This was after the UN General Assembly adopted the Universal Declaration of Human Rights. It is so profound that on a day like this, when we are meant to be celebrating and ensuring that the human rights of all individuals in this our country are respected, we are here because of a violation of human rights of Dr. Kiiza Besigye, of Haji Obed Kamulegeya, and other Ugandans that have been through this court that have suffered persecution of this military court. It is good that now, as the opposition, we are persecuted together. As NUP, we have had several of our supporters that have been persecuted by this court and several other opposition leaders. Now it is Dr. Kiiza Besigye. We are saying we are united against this injustice. And that's why we are here, to say no to this injustice, to say human rights must be respected. It is not okay, and they want to make it okay that they can persecute some of us and the rest of us move on as if it's business as usual. No. And we're calling upon all Ugandans out there. This should actually not just be a matter of the opposition. Some colleagues in the NRM have been persecuted too, freed by courts of law and they are rearrested and so on. So any lover of human rights in this our country, any lover of peace, should be behind the quest to see that we clip the wings of this military court. It should cease to operate the way it does. Olunaku olwaleero mu nsi yonna tujjukira ekiyitibwa International Human Rights Day kubanga UN General Assembly yagazetinga olunaku luno. Kitegeeza nti tuba tulina kubanga tujaguza nti eddembe ly'obuntu litwalibwanga ekikulu, naye tuli wano ku lunaku luno lwa International Human Rights Day kubanga ate eddembe ly'abannaffe abamu lityoboolebwa. Eddembe lya Dr. Kiiza Besigye, Haji Obed Kamulegeya ne bannayuganda abalala abazze batulugunyizibwa kkooti eno. Kirungi nti ffe nga ab'opposition tuzze katutandise okukwatira awamu ku nsonga zino netugamba nti bwe munaatulugunya omu ku ffe ffenna kijja tukwatako kubanga kyekize kitubeerako ffenna abawagizi baffe nga NUP bazze batulugunyizibwa kkooti eno ne bannayuganda abalala. Era nga tukuba omulange eri bannayuganda tewetaaga kubeerawo opposition n'aba NRM namwe bajja batulugunya olunaku lwammwe lujja kutuuka bwe mutaasitukira
Well, let me first thank the defense lawyers for standing firm and together to ensure that our colleagues who represents them, the statement the defense has made is good, and all peace-loving Ugandans, all Ugandans who want to see the rule of law need to understand that there is precedent. Two weeks ago, panel of leaders of East Africa, presidents, General Museveni was one of those. He's fond of talking about integration. I saw him doing analysis of what has caused weakness on this continent, and he was referring the chiefs of the past, which he does all the time. For Africa to be united, leadership at the top is very, very critical. You walk the talk. You don't say all the nice things, and your actions contradict what you talk about in public. There's absolutely no reason why, when Dr. Kiiza Besigye and Hajj Obedi Kamrege choose to have Honorable Martha Karua to be the lead counsel, and it becomes a problem. I absolutely don't see any reason why. But every cloud has a silver lining. Our colleagues now are going to be in prison maybe for the next, by 7th of January, it could have been like 2 months. Of course, they're going through a lot of pain. The silver lining in that you've stood firm, keeps on exposing this government to masquerade in life is not good. When you are masquerading, the longer a process takes, the more your real colors come out. Because people see contradiction between theory, what you talk about, and practice, what you do. So much as the two colleagues are going to suffer, it's good that time keeps on exposing these people in government. My advice, those who are in government, many of whom are colleagues because we serve together, no government is permanent. All of them leave power at some point. So I keep repeating what I keep raising all the time. When you arrest a retired officer, Major Iduri, he served honorably in the military. He retired. He has a right to represent whoever contracts him to represent him. You go and abduct him. I would like to ask all the officers who are in uniform, including the generals at the top, what do you think? When you honorably serve, many of them have been shot at. Many of them have been wounded. They have continued serving this country because many of them love to see justice, love to see peace, love to see a country which is developing. But when you have served and you have left, your own colleagues who are still in uniform come and treat you the way they treated that major. I don't even know him, I've never interacted with him. What does that mean to you who are still in uniform? What does that mean? That you make sacrifices for a country. That even when you get out of uniform, you have got rights like any other individual. You don't have to be on the side of the regime. You do whatever you want to do. That's the country we want to see. My advice, those who are in government, be sure that as day follows night, there's going to be a day when you won't be in those offices. I appeal to you, do things now when you are still in government that will enable you to leave uniform and offices, ministries, whatever, so that you can find a country where there is justice. Whatever you are doing, that you have got rights and freedoms that are going to be protected by the law, not by any individual. Not by any individual. We thank you, members of the press.
Thank you.
Right is might. That's what many people don't understand. Right is might. So the Ugandans who are terrified and they keep on withdrawing and say, oh, things are dragging on, things are dragging on. This is our country. This is our country. The only way we can shape the future to be as we desire it to be is to keep firm, including those who are in government. And to our, it's unfortunate this happened in a neighboring country, Kenya, which we have all always felt secure in. What they did now, imagine, exemplifies what happened more than 30 years ago. Because that's the last time a senior politician was abducted from Kenya. That was the late Mzee Barakiria in Nairobi. That was the second UPC government. When they abducted him from Nairobi, we know, those of us who were in the bush by that time, all our external committees scattered. They all ran out of Nairobi and they went to Sweden. They need to ask themselves, really, you want the same thing to happen 30 years thereafter? Finally, I see the law of cumulative effect unfolding. So we should not lose heart. Even those who are in Syria for 50 years never thought that Assad and his family would ever get out of power. But 1 week, he's nowhere to be seen. That's what the law of cumulative effect does. Those who are in government need to understand how it operates. Those who understand how it operates, I suspect will sober up. May God bless you all.
Thank you. Can you, before she takes over, just say one word about retired Major Iduri, because it's about liberty. Just something little senior. Something small about Iduri.
In the wee hours of this morning, as the defense team, which was burning the midnight candle to represent Rotary and Besigye, put finalized plans to come here and do a robust defense work, some criminals from UPDF abducted retired Major Ronald Iduri from his home in Werenga and disappeared him with the sole purpose of frustrating the defense team of Besigye and Rotary. We condemn that in the strongest terms possible, and we have urged the chairman of this military tribunal that if this is not to be projected as the kangaroo military tribunal it is, then they should restrain members of the UPDF from abducting members of our team. That is not the first threat against members of our team. We have been ignoring some signs of intimidation or directed towards the defense team, and we shall continue to ignore those methods. But we must assert the right of their choosing to a fair hearing, to a fair representation, to dignified treatment, to their liberties as guaranteed by the 1995 Ugandan Constitution. And we are not intimidated. We are not bullied. We shall come here in this military barracks surrounded by soldiers and continue to do the work of representing our people. We have also the grievance of being denied where to sit. Most of our lawyers today were not able even to get seats, and we have not even concluded the issue of representation because both the military tribunal is in cahoots with Museveni and the Law Council of Uganda and illegally trying to block the visiting jurists from Kenya from representing Besigye, contrary to his sacrosanct right to choose who represents him as a lawyer, how many lawyers represent him. So we are going to continue fighting these battles on all fronts. There is an all-out legal war against the injustice that has been meted out against our clients, and we shall keep you posted. Thank you very much.
Okay, very briefly.
Oh, sorry.
I want to first salute the Ugandan opposition for the solidarity. Ugandan members of the bar, that is the legal councils, who have teamed up to represent Kiiza Besigye and Mr. Lutale. That solidarity is needed in the wake of aggression and dictatorial tendencies. Now, you have witnessed for yourself, for the longest time when we started this press conference, a military police vehicle standing here with the siren on to obstruct. It has now moved away. You can see it has not gone anywhere. It is now neatly parked. Why couldn't they park to give us silence before? These are the forms of aggression that are happening daily, from obstruction to access. Yes, I was denied the certificate to practice by the Law Council. I am contesting that, not for myself. As my colleagues have said, what we are pushing is the right of Dr. Kiiza Besigye and Mr. Lutale to have a team of lawyers of their choice and to have a lead counsel of their choice. That is what we shall be pushing, and that is what the Law Council must consider. Not about me, but the right to counsel and counsels of choice. I want to say that beyond counsel of choice, even with the denial of the license, I appeared today as a jurist from Jumuiya to observe the proceedings. And because I remain a lawyer, whether the Law Council approves my license or not, I am at liberty to wear my attire to identify myself as a lawyer. And therefore, I came robed. My robes are not a criminal offense. My robes are a result of the training I have had. And nobody can strip me of my robes unless if I commit a criminal offense, which I have not. We are here today joined by a fellow jurist from Kenya. Let him just say his name and one word, and then a jurist from Angola will identify herself.
Kiiza Besigye is my name, an advocate of the High Court in Nairobi. I have put in my application to the Law Council to be enjoined into this matter. And we are going to follow it up until it is done. We are going to comply. We are going to appeal. We are going to push until it is granted. There's an issue that I'd like to address.
Kenya angetwetedde omuliro.
Being in Jumuiya that has started happening in Nairobi, which we never had, maskmen, abducting people at night. Now it's where?
Abayi, abaana b'e Kenya bayimbudde nno. Ekinaava wano. General Museveni anaakiwulira. Bino twanze obanga baabikola nga kaali kabadi nga mugwali muzannyo gwabwe naye gye bigenda okugera kigenda kubalya. Ebigenda okuva mugenda kuba birala nnyo. Era gwe Munnayuganda just watch the space olabe biki ebinaddirira. Ensonga ziyinza okukyukamu. Ebigambo biyinza okubalya someday. Katulinde tulabe ekinaaba kiddiridde naye ng'olaba Kenya is today enkundi n'omulala okuva mu Angola.
You may be aware, trial observation is an instrument to ensure human rights to fair trial and access to justice. It's a sign of there is a need for us as human rights defenders in Africa to join, be creative as well, and stand up against brutality, against authoritarian regimes, and defend the rule of law, which is the basis for guarantee human rights. So my presence here is to support all those lawyers, professionals, human rights defenders, but also be before the court and make the court accountable to the principles of the rule of law. Thank you.
Okay, finally, I just want to say to the Law Council, kindly, no double standards. If you could allow the President, Yoweri Museveni, to bring Kaminwa from Kenya, Dr. Kaminwa, my senior, for a civil matter. A criminal matter is more serious than a civil matter. That involves the life and liberty of Dr. Besigye and Mr. Lutale. No double standards. What's good for the goose is also good for the gander. Let them review their decision. We are going to contest it, and we expect that they will not apply double standards.
Kali byebyo ebya Besigye ne banne n'emisango gya General Kaguta Museveni yamuteekako egy'emmundu egyaki nenga kivuddeyo bwe kityo sobera olina by'oggyemu olina by'otegedde bw'obanga waliwo obuzeemu ddayo katandike ogenda kulaba gwe Mukama bakuume mweraba tujja kuwangula very soon.